Appeal in the matter of Navigtator Equities Ltd and another and Deripaska.
Please the court. I appear with my learned friend Mr. Wheel for the appellant, Mr. Grant and Mr. Wright appear for the respondent. I imagine your lordships have had an opportunity to do some pre-reading. I hope you've got the core bundle, the authorities bundle and the supplemental bundle insofar as it was originally lodged. There was some late additions which we were asking to put in. I don't know if those have formally got in front of you and whether it's more convenient to deal with additional.
We've got them.
You've got them.
Is there any objection to their being referred to?
We're not objecting to what my learned friend wants, and I think when he last wrote, he didn't say he was objecting, or his solicitors didn't say he was objecting. So
No.
if that's acceptable, can we proceed on the basis that those are in? The issues, as you, I'm sure, well aware, fall under two broad headings. One is the substantive merits as to whether the judge below was correct in dismissing the committal application, and the second and much shorter headline point is even if the judge below was right on the substantive issue, was he right in awarding Mr. Deripaska costs on the indemnity basis in respect of at least part of his costs. That will take up far, far less time. In terms of roadmap, I anticipate being on my feet until about 3:30 today. Thereabout. My learned friend has a number of points by way of additional grounds, which so I'll want to leave a certain amount of time to reply tomorrow. But for the purposes of today, we were going to address you under 5 broad headings. First of all, just to make some introductory remarks about what is in issue and what isn't. Secondly, to address you on the interpretation of the undertakings. Thirdly, on the question whether there was a breach. Fourth, if so, whether it is open to us to say that any breach was deliberate. You will have seen my learned friend wishes to argue that that is not open to us. So, fourth question is, can we say the breach was deliberate, and if so, should this court decide that, or does that have to go off, remitted to the court below? And then fifth heading will be the costs appeal. Turning then to the first of those headings,
None of your headings, Mr. Crowe, answers one of the central themes of Mr. Grant's skeleton argument, namely that the case that you wish to advance on the interpretation of the undertaking is not the case that was advanced below. So is that going to fit into one of your headings somewhere?
Absolutely will, yes. Not as a separate heading. So the main issue, turning to my issues and what is an issue and what isn't an issue, the main issue, as you will have seen from your pre-reading, is that the judge below decided that the committal application was entirely premised on an allegation that the shares in EN Plus were cancelled as a result of the redomiciliation of the company to Russia. And the judge held that in the absence of expert evidence, my clients had failed to prove that the shares in EN Plus were cancelled. Our response to that is the judge is wrong, both as to his conclusion and as to his approach. And we submit that what he should have done was first to interpret the meaning and effect of the undertakings. Secondly, to decide whether my clients had proved that what Mr. Deripaska did or failed to do, whether we had proved that Mr. Deripaska did or failed to do the various acts alleged in the committal application, and then thirdly, to assess whether those actions and that inaction constituted breaches of the undertakings as alleged. And if the judge below had done that, we submit that he would have recognised that the only relevant point of foreign law was common ground, and indeed was self-evident, which, without anticipating too much, is simply that on migration, the company ceased to be a company registered and governed by Jersey law. So the approach we say the judge below should have taken, and the approach we will be taking, as I say, in our oral submissions, is first of all to spend some time interpreting the undertakings to see if the matters which have been alleged in the committal application and proved constitute breaches. And we submit that if the judge below had done that, and if this court does that, we submit that the correct conclusion is that the alleged contempt has been proved. Just a couple of very short remarks on what we say is not an issue. My learned friend opens his skeleton with a complaint that the committal application is oppressive and unfair, which he says that's paragraphs 4 and 5, and he says that it serves no private or public interest in paragraph 6 of his skeleton. We, with respect, submit that that is not an issue that needs to detain you. The allegation that the committal application was an abuse has already been advanced and failed. It succeeded in front of Mr. Justice Andrew Baker, but it failed in this court, and I think some of this constitution, no, sorry, you heard an earlier appeal.
No, we're not. I think I may have given leave.
You did that, yes, indeed, so you did. You're right, my lord. So the question whether or not the committal application was an abuse was unsuccessful in this court, and this time around, permission to appeal to this court has already been granted by Lord Justice Phillips. And in our submission, that being procedurally the position, it simply isn't an issue for this court. But it's not open to my learned friend in this court to be arguing that the determination of an appeal in respect of which permission has already been given is oppressive or unfair, nor, for that matter, is my learned friend entitled to complain about the time that has been taken since November 2019, when the committal application was issued, to today. It is regrettable that it has taken so long, but the a cause of that has been the unsuccessful strikeout application, and it may also be said a number of disclosure applications which were unsuccessful, and my learned friend really can't complain about any passage of time that has resulted from his client's taking points which ultimately failed. So we simply invite your lordships to decide the legal issues in the appeal without being distracted by any noise in relation to unfairness or delay from the other side. The other very preliminary point I just wanted to dispose of at the outset is a submission from my learned friend that any breaches have long been cured, he says in paragraph 4.4 of his skeleton, have long been cured by his client having paid everything that was due. That is no doubt intended as a reference to the payment of the sum due under the arbitral award, but our submission in response is that the substance of what my learned friend is hotly contested in this sense, that although Mr. Deripaska did ultimately, 2.5 years late, pay what the arbitral tribunal ordered, the breaches of the undertakings about which my client has complained have caused significant losses, and it was those losses that my client sought to recover by way of damages. We don't need to go into them, but they are explained in Miss Barrard's 8th witness statement of paragraphs 106 to 114. I don't ask you to go to that now. The other point is that essentially a close cousin of this submission was run in front of the Court of Appeal the last time we were in this court, and it was dealt with, it didn't find favour here. It's mentioned as one of the submissions in paragraph 75, sub 4 of the Court of Appeal's judgment. It didn't find favour then, and in our submission it should not do any better now. So that's all we just wanted to say to put the issues in context of what is in play. Turning to the second main heading, that is the interpretation of the undertakings. As you are, I'm sure, well aware from our skeleton and pre-reading, the last time we were in this court, the Court of Appeal gave a judgment through Lady Justice Carr, as she then was, explaining in some detail why there was an arguable case that on the true interpretation of the undertakings there had been serious breaches of those undertakings, and you will have seen we've quoted some of that in our skeleton argument, and the key paragraphs, again we don't need to go to them now, but the key paragraphs are 97 to 99 and paragraph 104 in the Court of Appeal judgment, which is in tab 44 of the supplemental bundle. And as Lord Justice Phillips said when granting permission to appeal, perhaps one of the most striking things about the first instance judgment in this case is that the judge below didn't offer any analysis as to why he disagreed with the Court of Appeal's interpretation, let alone explain why he disagreed, if indeed he did. Can we just look very briefly at how the judge below dealt with what the Court of Appeal had said?
Could we look at the Court of Appeal first, Mr. Crowe?
Yeah, certainly. So that's tab
44.
44 of the supplemental.
104 you particularly focused on, which is page 286.
Yeah.
And what Lady Justice Carr says is that the following analysis on the law and facts was at least properly arguable.
Yeah.
Then she talks about breach of positive undertaking, failed to take all steps necessary.
Yep.
Underlying assets were the Jersey shares. And then B, the Jersey shares did not remain available for direct enforcement upon completion of redomiciliation, since they then ceased to exist.
Yes.
So that's the factual foundation, at least for assumed purposes, for the purposes of the judgment of the Court of Appeal. And if one reads her judgment, there are many, many places in which the underlying factual premise is that the Jersey shares cease to exist.
Yes. Absolutely. And that, well, I mean,
the next sentence which follows on from that, the replacement shares in Russia were not the same shares.
indeed. Well, that is the case. The case that we are advancing is that the subject matter of the undertakings was certificated shares in a Jersey registered company. It is the case that on redomiciliation, those shares ceased to exist in the relevant sense for the purpose of the undertaking, because after the redomiciliation, there were no certificated shares in a Jersey registered company. What then existed was dematerialized, non-certificated shares in a Russian company. The question whether the Russian company, as a matter of either Jersey or Russian law, can be regarded, or both, can be regarded as the same legal entity, in our submission doesn't matter, for the purpose of identifying whether what happened resulted in the subject matter of the undertakings ceasing to exist. I was hoping to get to that punchline a little later, but I can see that it's at the forefront of your Lordship's minds, and so I just wanted to explain exactly how we get there. Once you've identified the context in which the undertakings were given, the purpose that was intended to be served by the package of undertakings, which includes depositing the share certificates with London solicitors, The fact is that the subject matter of the undertakings is certificated shares. Otherwise, there would be no point in the RPC undertaking to hang on to those share certificates. If the consequence of the redomiciliation is, which it is, that the company is no longer a Jersey registered company, and therefore that the subject matter of the undertakings does not exist anymore, then the breach that we have always alleged has been committed. We are not making some abstract point of company law about whether or not the Russian entity is the same legal person as the Jersey entity. We are saying that the thing that has ceased to exist is the undertakings shares, and the undertakings shares are, in our submission, self-evidently certificated shares in a Jersey registered company. And indeed, it's apparent in our submission on the face of the committal application that we recognise that the word continuance of EN plus Jersey into EN plus Russia is how the legislation seems to describe it. Paragraph, I wasn't going to get to it, but we will get to paragraph 20 of the committal application in due course. We use the word the continuance. The focus of the debate has never been, is the Russian entity a different legal person? The debate has always been, have the undertaking shares ceased to exist? And that's what matters. That is, in our submission, the case we have always run. I've anticipated a certain amount of what I was going to say. I don't know if that's if I can then go to the first instance judgment. So that's in the core bundle of tab 6. And the key paragraph is going to be paragraph 30, which is at page 57.
Paragraph
30 at page 57. And for the purposes just of understanding how the judge below addressed or didn't address the Court of Appeal judgment, he says two things in paragraph 30. He says first that the Court of Appeal judgment isn't binding on him. He says in the first few lines of that paragraph, make clear that nothing said by Lady Justice Carr in her judgment overturning the first instance decision striking out those proceedings was intended by her to be a finding binding on me concerning the substantive merits of the application. I have not treated her findings as such. That's the first point. Now, as a matter of form, yes, that is absolutely true. What the Court of Appeal said, as was just read out, was that it was arguable that this was the correct interpretation. But where a Court of Appeal has given a detailed judgment explaining what is an arguable interpretation in relation to a matter such as this, for the judge below simply to have then disregarded it, as he did, on the basis that it wasn't binding, and without explaining why, if he does, he disagrees with that interpretation, in our submission, if nothing else, plants seeds of doubt as to whether or not the judge has taken a defensible, justifiable approach. And that is further, the concern there is further undermined when one sees the next sentence, because he appears to have misunderstood the proceedings in the Court of Appeal. The Court of Appeal proceeded on the assumption that the claimants had a realistically arguable case on the merits, that there had been more than a mere technical breach by the defendant. There was no assumption made. The Court of Appeal referred in some detail to the underlying evidence as to the context in which the undertakings were given. And they explained, as you know, from the length of paragraph 104, but also paragraphs 97 to 99 of the Court of Appeal judgment, they explain in some detail why they say there is an arguable case of a serious breach. So for the judge to have brushed that aside on the basis that the Court of Appeal was making an assumption rather than a reasoned judgment in our submission is plainly wrong. And he clearly then does, if we just go on to paragraph 38.
Your point is the Court of Appeal decided that was not an arguable case.
They decided it was an arguable case, yes. They didn't simply say, well, for the purposes of deciding, I mean, the main issue, in a sense, in the Court of Appeal on that occasion was, does the alleged motive of my client in bringing the committal application make what might otherwise be an arguable contempt of court an abuse, because it was allegedly being pursued through malice. The Court of Appeal could have just made an assumption and said, well, we'll conduct the argument on motive, the relevance of motive, on the assumption that there's a reasonably arguable case of breach. But they didn't do that. They analysed the underlying evidence, and they explained in paragraphs, as I say, 97 to 99 and 104, why there was an arguable case. And for the court below to have disregarded that is in our submission simply a wrong approach. If we then go on to page 64 in the core bundle, paragraph 38, where my submissions to the judge below are set out, and our reliance on what the Court of Appeal had said is quoted. Don't need to dwell on that, but if we then just go over and see how the judge dealt with that at the top of page 65, where he says, as I said earlier in this judgment, these conclusions are not binding on me. Lady Justice Carr was not reaching any final conclusions on the merits of the contempt application because it had not been determined. Much less was she reaching conclusions applying the criminal standard of proof. Well, all of that is true. But he then says, although Mr. Crowe described these conclusions as provisional, in truth, they were concerned with issues that it was not necessary for the Court of Appeal finally to decide, and in my judgment, they must be left out of account by me in reaching a conclusion on the issues I have to decide. That, in our submission, is putting it pretty high, where a Court of Appeal has given a detailed and reasoned judgment on the point. And our concern is further heightened if one just looks very briefly, because this was immediately after the substantive judgment. We get a judgment on costs, which is at tab 7 in that bundle. And one gets another window into how the judge regarded the Court of Appeal judgment from the costs judgment, because it was being said in relation to the request for indemnity costs, it was being said on behalf of my clients, well, the Court of Appeal did say that the case was reasonably arguable. Seems a bit rough to start inflicting indemnity costs. And if one looks at how the judge dealt with that in paragraph 10 of his judgment, which is in tab 7 at page 79, he says, in my judgment, the materiality of the decision of the Court of Appeal to the issues I have to decide must clearly be set in its context. The Court of Appeal did not attempt to evaluate whether the breach had been demonstrated, much less did the Court of Appeal attempt to evaluate that to the criminal standard, which is the test that has to be applied at a trial. Therefore, it seems to me, the view that the Court of Appeal took in the context of a narrowly focused appeal on a procedural aspect of the claim is not an outcome which detracts necessarily from the point that on in-depth analysis, the application as framed was evidentially flawed. So the judge is there apparently regarding the Court of Appeal hearing as a narrowly focused appeal on a procedural aspect of the case, which, with the greatest respect, it just wasn't. So, we do suggest that the judge was wrong in disregarding the Court of Appeal's ruling, and he may have been right in saying it wasn't binding, but it would, in our submission, have behoved him to explain whether he disagreed, and if so, why. And as I say, it was partly, significantly on that basis that Lord Justice Phillips gave permission to appeal. Just as a footnote point before moving on, we do say that because the judge does not, in fact, explain why he disagrees, if he does disagree with the Court of Appeal, and indeed it doesn't ever, anywhere, explain overall what his interpretation of the undertakings actually is. It's one of the striking things about the judgment below, is there isn't a section analysing what the purpose and effect of the undertakings were. And just as an incidental point, as a consequence of that, my Lord, we would submit that my learned friend is wrong to say, as he does a couple of times in his argument at different stages, he is wrong in saying that we are inviting this court to find that the undertakings were clear and unambiguous in circumstances where the judge below disagreed. He says we are inviting this court to take a different view of the undertaking, meaning of the undertakings from the judge below. I do not see where the judge below's understanding of the meaning of the undertakings is expressed. What we are in fact doing is asking this court to take the same view of the meaning and effect of the undertakings as the Court of Appeal did the last time we were here in this case. So just with those few words, the correct approach in interpreting the undertakings is obviously to read the words used in the context, in the relevant context in which they were expressed, by reference to the vice, the purpose, however you wish to describe it, that they were intended to address. My learned friend, in paragraphs 55 and 56 of his skeleton, my learned friend seeks to argue that it is illegitimate to look at the archaeology, as he chooses to call it, the evidence that was filed at the time, the correspondence leading up to the undertakings, and the submissions that were made by counsel for Mr. Deripaska in court. So I just want to address you very briefly first on the relevance of context in interpreting undertakings that are given to court. And we just have a few very short submissions to make on that. The first is simply that it is entirely orthodox and proper to construe court orders and undertakings in the relevant context in which they were made. I think both sides rely on SDI retail and Rangers in that regard, or at least we relied on in that regard. I will just look at a couple of sentences in that. It's in the authorities bundle at tab 12. And if we just look very briefly at paragraph 44.3, so if we look at page 424.
We've got is a supplementary bundle on the screen, not the authorities.
Yes, authorities bundle, tab 12, page 424, where the judge says, paragraph 44, the judge handed down his reserved judgment. The relevant legal principles had been common ground before the judge as they were on this appeal and were summarised by him by reference to the following authorities. And then if we go over the page to a quotation from Abliazov, paragraph 3, subparagraph 3 at the top of the page, the words of the order are to be given their natural and ordinary meaning and are to be construed in their context, including their historical context with regard to the object of the order. And we get the same in paragraph 60 on page 428. Paragraph 60, just the first couple of lines. As the authorities cited by the judge make plain, the interpretation of the injunction is an objective exercise determining what the language used conveys in the context in which the order was made. And 63, that proves to be the basis upon which the Court of Appeal in that case took a different view from the judge below. In my judgment, the judge did not give sufficient, if any, consideration or weight to this broader context and purpose of the injunction in considering its interpretation. So our first point is that, as I say, it is entirely orthodox and proper to take into account context. The second point, which in a sense is no more than an illustration of that, is that the Court of Appeal did exactly that the last time this case was in this appellate level, and we see that from, if we go back to the supplemental bundle, tab 44, page 279, and you'll see at paragraph 82, Roman 4, the meaning and effect of an undertaking are to be construed strictly as with an injunction. It is appropriate to have regard to the background available to both parties at the time of the undertaking, when construing its terms. There is a need to pay regard to the mischief sought to be prevented by the order or undertaking. And that is exactly what the court then did. We don't need to go into the details, I'll go back to it later on. But you'll see that is the basis upon which the court took a different view from Mr. Justice Andrew Baker, in that case at paragraph 99. Well, 98 and 99, the judges, where they're dealing with the judge's conclusion that the redomiciliation was not negative but positively beneficial to the appellants, and they say in para 99, but as set out above, this is to miss the essential purpose and effect of the undertakings. And they describe that purpose as being all about securing assets for the appellants that were outside Russia. So our second point, as I say, is that context is plainly irrelevant in interpretation, and that is what the Court of Appeal did in this case. The third point, for what it's worth, is that that is exactly what leading counsel, then appearing for Mr. Deripaska, invited the Court of Appeal to do at the hearing leading up to this judgment. We didn't go to it, but we've got the transcript where my learned friend's predecessor positively submitted that context was relevant. Day 2, page 344, which is in the supplemental bundle, tab 43, page 253. And the final point is simply to observe that when it suits my learned friend's purposes, he seeks to do exactly the same thing when he thinks it supports his client's position. I'll let him develop his own submissions in paragraphs 25 and 26 of his skeleton. But when he does, you will note, as I say, that when he considers that it assists Mr. Deripaska's purpose, he does resort to contextual arguments. So in our submission, there really can't be any sensible doubt that interpretation is an exercise which requires the context to be taken into account. And one of the early errors in our submission in the judgment is that having recognized the importance of taking account of context, the judge then positively doesn't do so. It's partly a result of the structure of his judgment, but you will see at paragraph 31, subparagraph 8, which is in the core bundle, tab 6, page 58. Core bundle, tab 6, page 58, at the very bottom of the page, Roman 8. In relation to context, the words of an undertaking are to be given their natural and ordinary meaning and are to be construed in their context, including historical context and with regard to the object of the order. And he cites Pan Petroleum, and indeed he cites the Court of Appeal decision in the earlier outing to the court. So he states the principle, but the peculiar thing about the judgment is that he has already explained the context earlier before identifying what the correct legal approach is. And he has already said he doesn't need to deal with the context. So if we go back in the judgment to page 48 of the bundle, paragraph 8, Paragraph 8 said, broadly, the undertakings were proposed on the basis that the defendant was the ultimate beneficial owner of a company called Fidelitas, a company registered in Panama, which in turn owned all or nearly all the shares in B Finance, which in turn owned 245 million unencumbered shares in EN Plus. After negotiations which I need not take up time setting out, the claimants withdrew their application to continue the worldwide freezing order. So the contextual matters which the Court of Appeal themselves specifically referred to, and which as a matter of principle he acknowledged would be relevant, he's already said earlier in the judgment he doesn't need to take time setting out.
Well, could I ask you this, Mr. Crowe? You've said, as far as I'm concerned, correctly, that the interpretation of an undertaking is an objective exercise to be conducted against the background, the context, and the purpose of the undertakings. And that's much the same approach to the interpretation of a contract. If this were a contract, which was to be interpreted applying those principles, we would leave out of account negotiations which preceded the making of the contract, and we would also leave out of account the subjective understandings of the parties to that contract. Why should the approach be any different when interpreting a court order?
Partly, well, what is part of the context? With respect, I think it's potentially dangerous to sort of lay down an abstract rule that something that's in a letter must be inadmissible. If what appears from the correspondence is evidence of what the object of the undertaking was, and if that correspondence reflects the concerns of the party, in this case, who sought a worldwide freezing order, and identifies the purpose of the freezing order and the intended purpose of the replacement undertakings that were being offered to discharge the worldwide freezing order, then the negotiations are part of the context in identifying what the subject matter and the objective of the undertakings were. And that is, I apprehend, what the Court of Appeal did on the last occasion in order to identify the purpose and intended effect of the undertakings. They refer to the negotiations. I can just see if I can find. Yeah, so it's later on in paragraph 99 of the Court of Appeal judgment back in the supplemental bundle, tab 44, page 285. As set out above, this is to miss the essential purpose and effect of the undertakings. The undertakings were all about securing assets for the appellants that were outside, page 285 in the supplemental bundle. The undertakings were all about securing assets for the appellants that were outside Russia and available for ready enforcement of the award. As set out above, the issue was not whether Mr. Deripaska was sufficiently wealthy to satisfy the award, but whether there were assets outside Russia against which the appellants would be able to enforce. The ability to enforce was the consistent and understandable concern of the appellants, identified from the very outset and recognised as such by Mr. Deripaska. Reference can be made to oral submissions of Mr. Fenwick, BCLP's letter. BCLP was then representing Mr. Deripaska to Clifford Chance. Second witness statement, Mr. Ray. Further, as already indicated, Russian assets were excluded from the worldwide freezing order and so on. So reference is made there to a collection of evidential pieces. And if the correspondence demonstrates what the concerns of my client were at the time, and they are concerns that are communicated to Mr. Deripaska, and Mr. Deripaska is offering undertakings in order to meet those concerns, then that correspondence is, in our submission, evidence of what the purpose of the undertakings ultimately was, because it is evidence of the function that the undertakings were intended to fulfill, to deal the risk that my client felt existed about an inability or great difficulty of enforcing anything in Russia. Mr. Deripaska's knowledge that that was our concern. I'm not suggesting he shared the concern. Our case is not dependent on proving that Mr. Deripaska admitted that there would be difficulty of my client enforcing in Russia. The point is simply that that was my client's concern. Mr. Deripaska knew it, and he offered the package of undertakings in order to meet that concern. And that is, that in our submission, the context, and that contextual body of evidence is comprised in witness statements, correspondence, and submissions made in court. As I say, my lord, we do submit that paragraph 8 of the judge's judgment does demonstrate that although later he acknowledged as a matter of principle context was relevant, he had in fact earlier said he doesn't need to deal with the context. And that's one of the many illustrations of why in our submission the judge ultimately takes the wrong, gets to the wrong conclusion, because he's actually taken the wrong approach. So to run through very shortly the context that was known to the parties, just by way of very brief background, what was clearly known to both parties was the whole lead-up to the worldwide freezing order. And if I could just recap that very briefly, just so that the court is at, so to speak, the starting point of where the undertakings were being offered. The story begins in the late 1990s, early 2000s, when Mr. Chernukin, my client, was a finance minister under the then Prime Minister, Mr. Kasyanov, and my client was also chairman of one of the larger Russian banks, VEB. In 2001, he became aware of an opportunity to acquire a company which has been known simply by its initials, TGM. TGM owned a very large site in what, when it was built, I think in the 19th century, was the outskirts of Moscow, but was now pretty well in central Moscow. It was built as a mill, the fabric mill. The photographs of it make it looks not entirely dissimilar to Covent Garden. It's rather what we would now regard as charming red brick, but clearly was entirely functional when built. But a very valuable, I think, 9-hectare site in the middle of Moscow. My client approached Mr. Deripaska to see if he was interested in acquiring the site through acquiring the company that owned it, and they agreed on a joint venture, although there was no written agreement at that stage. But the shares in TGM were duly acquired in 2002. Then in 2004, the whole context of this is relevant. It may sound like old history, but the chronology is relevant. 2004, the then Prime Minister, who in a sense was, patron may not be the right word, but certainly the Prime Minister under whom my client was minister, Mr. Kasyanov, fell out of favour with Mr. Putin and was removed. And my client, Mr. Chernukin, fled to England, where he has lived ever since and became a British citizen in 2011. So my client, from then on, 2004 onwards, is in London. Mr. Deripaska is in Moscow. Shortly after that, in 2005, the parties then did negotiate and sign a written joint venture agreement, and that's where the joint venture vehicle companies come in. Mr. Deripaska's vehicle was the company Filatona. My client's vehicle was Navigator, and they jointly owned the joint venture vehicle Navio, which is a Cypriot company. And that agreement, that written joint venture agreement, it's described as a shareholders agreement, included a London arbitration clause, which is why the whole thing ended up being fought out here. The oddity was my client chose to put his then partner, girlfriend, however one describes it, as a named party to the agreement, and she was also named as the beneficial owner of Navigtator. Our case was, and ultimately this was accepted by the courts, that my client was the disclosed principal of Miss Danilina, and that Mr. Deripaska knew perfectly well that my client was a joint venture partner because they had been partners in the business since 2001. In any event, between 2005 and 2010, the joint venture jogged along, not very productively, but relations between my client and Mr. Deripaska became increasingly strained. And in December 2010, there was an armed takeover by Mr. Deripaska's men of the business premises in Moscow. If you want to cast an eye over Mr. Justice Tier's findings on that, I'm not going to go to them now, but it's paragraphs 242 to 243 of his trial judgment, which is in the authorities bundle, tab 9, page 230. Paragraphs 242 to 243, armed takeover. Immediately after that takeover, Mr. Deripaska made an offer to acquire my client's interests in the joint venture, but ultimately the negotiations were unsuccessful, and that resulted finally in my client launching the arbitration proceedings in 2015, alleging prejudice and oppression under the Cypriot equivalent of Section 994 of the English Companies Act, the unfair prejudice provision. That arbitration was challenged by Mr. Deripaska on the basis that my client wasn't the joint venture partner, Miss Danilina was. So there was initially a jurisdictional hearing in the arbitration, which essentially was a question of who is the true joint venture partner to Mr. Deripaska. The oddity of that was that neither side calls Miss Danilina as a witness, but the arbitral tribunal heard evidence from a number of witnesses, including Mr. Chernugin and Mr. Deripaska, and they reached the conclusion that Mr. Chernugin was the joint venture partner, and they gave that arbitration award in November 2016. So the jurisdictional argument by Mr. Deripaska that Miss Danilina was the true joint venture partner failed. Very shortly after that, so that was the arbitral award on jurisdiction in November 2016, the very next month, Mr. Deripaska, it turns out, entered into 2 agreements with Miss Danilina, agreeing to pay her a $2 million payment up front to bring a claim against my client, alleging that she was the joint venture partner, and agreeing to pay a $10 million success fee if she won. And he agreed by a separate funding agreement to provide her with $3 million by way of costs, legal funding. It was dressed up as an acquisition agreement of Miss Danilina's interest in the joint venture. In our submission in the courts and in the arbitration, it was quite obviously simply a bribe by Mr. Deripaska to Miss Danilina to bring a claim which they both knew was false. And that is the finding that Mr. Justice Tier finally made at trial, that they both knew Miss Danilina's claim was false, and Mr. Deripaska knew all along that Mr. Chernugin was his partner. Having had the jurisdiction hearing at the arbitration in 2016, in 2017 we then have the merits hearing in the arbitration, which my client wins, and Mr. Deripaska is ordered to pay $95 million, give or take. So that brings us to July 2017. Then in April 2018, things change with US sanctions as a result of political developments. And it's important at this stage of the chronology just to look at the opening stages of the correspondence to see what the concerns were. And we go first in the supplemental bundle to tab 1, page 5. This is a letter from Clifford Chance, who then represented my clients, to BCLP, Mr. Ray at Brian Cave, Leighton Paisner, who then represented Mr. Deripaska. And you'll see paragraph 2, press release by the US Department of Treasury dated 6th April 2018 states the reasons for the imposition of the sanctions on Mr. Deripaska. Oleg Deripaska is being designated pursuant to blah for having acted or purported to act on behalf of, or directly or indirectly, a senior official of the government of the Russian Federation, as well as pursuant to another instrument for operating in the energy sector of the Russian Federation economy. Deripaska has said that he does not separate himself from the Russian state. He has also acknowledged possessing a Russian diplomatic passport and claims to have represented the Russian government in other countries. Deripaska has been investigated for money laundering. He's been accused of threatening the lives of business rivals, illegally wiretapping a government official, and in taking part in extortion and racketeering. There are also allegations that Mr. Deripaska bribed a government official, ordered the murder of businessmen, and had links to a Russian organized crime group. I'm simply putting that in front of you in order to explain the objectively justifiable grounds my clients had for a concern that if they ever had to pursue an enforcement remedy against Mr. Deripaska in Russia, they would self-evidently encounter very significant difficulties trying to pursue somebody who was that closely associated to the Russian government and whose business interests were significant holdings in underlying economic activities which were a central part of the Russian economy, namely the exploitation and extraction and export of raw materials. I'm not asking you to take a view as to whether all of those allegations were true, but it is, in our submission, self-evidently part of the context that then led up to the litigation that then follows. And we'll see that is explained over the page on page 7 of the bundle, paragraph 7. Excuse me. As you will recall, we have previously raised our clients' concerns about the availability of Mr. Deripaska's assets for the purposes of enforcement of any award of costs in the present proceedings. The sanctions have caused our concerns to deepen further, still further. And then over the page again, in light, paragraph 10, in light of the sanctions and the subsequent deterioration of Mr. Deripaska's global business interests, we are deeply concerned about the prospect that Mr. Deripaska may be taking or planning steps to dissipate his assets and or repatriate them to Russia, where they will effectively be immune from enforcement. The effective immunity of Mr. Deripaska and his assets in Russia is obvious as a matter of general knowledge and confirmed by the imposition of sanctions by the US authorities. It is clear that the sanctions have been imposed on him precisely because Mr. Deripaska enjoys a status in the Russian Federation that would make Russian enforcement action against him and his assets difficult or impossible. In all the circumstances, our clients are now highly concerned, not only about the enforceability of any order for costs in the present High Court proceedings, but also about the enforceability of the second partial final award rendered in the arbitration, once the currently pending arbitration claims and Mrs. Danilina's proceedings have been concluded. So the whole starting point for this thread that leads up ultimately to the giving of the undertakings is precisely there explained as being the risk of Mr. Deripaska retreating his assets to Russia and the risk that any enforcement that may have to be brought in Russia would be fruitless. That is then further explained in the witness statement that was made in support of the application for a freezing order, which is at tab 3 of this bundle. You'll see, again, just recapping on the background, paragraph 6, 4 lines down, there's the reference to the arbitral tribunal having made extremely serious findings against Mr. Deripaska in the course of its award, including in relation to his involvement in an arms takeover of the joint venture business and his propensity to use improper means in order to frustrate the claimant's claim against him. For the reasons set out below, paragraph 8, we have reason to believe that unless restrained, Mr. Deripaska will take unjustifiable steps to dissipate with the effect of impeding the enforcement of the awards. And then paragraph 9 refers to the press release we've just seen, identifying the sanctions. Paragraph 14 over the page highlights the point, again, which we've already seen from the press release about Mr. Deripaska's status in the Russian Federation and his effective immunity there. And over the page 16 of the bundle, we quote findings from the tribunal about the armed takeover. We don't need to dwell on them, but that just gives you the evidential hook for that. And paragraphs 70, so that's 76 and 77 is the armed takeover, 78 to 80 deal with influence in Russia. And on that basis, if we go forward to paragraph 85 on page 18, the assertion is made that there is credible evidence to suggest that Mr. Deripaska will use any means at his disposal, whether lawful or otherwise, to frustrate the claimant's claims against him, and that he would not hesitate to take steps in relation to his assets which would have the effect of putting them outside the claimant's reach. The coda to that over the page at page 19, paragraph 105, was that the court was invited to disregard the value of any assets in Russia for the purpose of the application for the worldwide freezing order. The application, so that was a witness statement made in May, I think, of 2018. On short notice, the application was made for the worldwide freezing order on the 8th of May, and the order itself is at tab 4. We may need to look at individual paragraphs in due course, but essentially the effect was a worldwide freezing order, as you'll see from paragraph 4, page 21, restraining the defendant from removing from England and Wales any of his assets which are in England and Wales up to the value of £87.5 million, or in any way disposing of, dealing with, or diminishing the value of any of his assets, whether they are in England or outside, up to the same value. The paragraph 7c on the next page, 22, reflects paragraph 105 of Miss Berard's statement, where 7c says, in determining the value of the defendant's assets pursuant to the second sentence of subparagraph B above, pending further information pursuant to 8 and 9, no account should be taken of any such assets based in Russia, regardless of whether such assets are held through shares in companies outside Russia, save for the defendant's interest in shares in companies quoted on the London or Hong Kong Stock Exchange. Millennia Friend mentions in parenthesis in his skeleton that shares in EN Plus were quoted on the London Stock Exchange. That is not strictly correct. GDRs, Global Depository Receipts, are what are traded on the stock exchange. what was offered, as we will see, by way of security in the undertakings was certificated shares, not traded GDRs. The certificated shares are not tradable. We'll no doubt may go back to the freezer for particular points, but that order was then made. The next step, so that order is made on the 14th of May, just 4 days later.
11th of May.
I'm sorry, I was looking at the seal on it, sorry. It may well be in the 11th. Just a few days later, Mr. Deripaska's Russian lawyers send my then solicitors an email offering undertakings in exchange for my clients agreeing to discharge the worldwide freezing order. The email itself is not as a freestanding document in the bundle, but it is, for the relevant parties, quoted in tab 48 of this bundle. If we go through, I read it out to the court at the trial court below, and it's at tab 48, page 344.
Yeah.
And you'll see, so it's the bottom left-hand page, page 10 of the transcript. And I'm saying to the judge, most importantly, that is the offer of the undertaking, didn't come from this side. It came from his Russian, Mr. Deripaska's Russian legal team. You may recall, in the course of giving evidence and in re-examination, efforts have been made somehow to sort of distance Mr. Deripaska from his London lawyers. The one document I want to go to for this purpose is the letter from Ms. Kaldina. She is his lawyer in Russia, or at least one of them, specifically assigned to deal with this case, reporting directly to him, as she says in her agreed, and as she says, and he agreed in evidence. So it's critically important to understand that this undertaking is offered by her, and you may recall in the last 6 or so lines of that first page, their intention. Our client's intention is to provide you with a suitable security in the form of undertakings in respect of EN Plus shares to the value of £125 million, or in the alternative, a Russian bank guarantee, in the amount of such to be held as security in England and Wales up until the final resolution of the case. So the submission that was being made to the whole origin of this undertaking was to provide Mr. Chernukin with security here and not leave him having to chase an asset in a Russian registered company with a Russian shareholder register. So the starting point for the offer of the undertaking is a letter from the Russian lawyers, which expressly refer to holding security in England. That thread is then picked up by BCLP in about a week later. If we go back in the bundle, same bundle, tab 5, and you'll see just in this, so page 33 of the bundle, second paragraph, Mr. Deripaska is prepared to make an offer in the terms set out in this letter in return for your client's agreement to the discharge of the order. I just draw that to your attention because there is, I don't know if it's going to be pursued, but there is an indication in my learned friend Skeleton that he will seek to invite the court, this court, to disagree with the finding that the judge below made, that Mr. Deripaska procured the key vote. So the question of who's making the offer is relevant. And it is clear here that BCLP is saying that Mr. Deripaska is prepared to make the offer. And over the page, page 34, a third of the way down the page, Mr. Deripaska will procure, by agreement with B Finance, with a view to obtaining a discharge of the order, and entirely without prejudice to our comments in 2 above. They are reserving their position, saying the worldwide freezer should never have been granted. but without prejudice to that, they say they're offering an undertaking that B Finance that B Finance arranged to deposit with solicitors in London one original share certificate with respect to the then offer was 35.5 million. It went up to 45.5 million unencumbered shares owned by it in EN plus the shares. And then paragraph 2, the solicitors, Ronald Porter Chamberlain, have been nominated for the purpose, will undertake to the English court on irrevocable instructions from B Finance to hold the share certificate and not deal with or dispose of the shares in any way. And then we get in para 3 the offer of an undertaking from the director of B Finance. And then over the page, paragraph 4, the effect of these arrangements will be that Mr. Deripaska will have made arrangements for assets with a value well in excess of 125 million, of which he is the ultimate beneficial owner, but not direct owner, to be made available in London, to be held pursuant to paragraph 4 of the order and offered them as security for the purposes of paragraph 9E2 of the order. So what we get from this letter, again, is first of all, perfectly clear assertions that this is all being procured personally by Mr. Deripaska, which will be relevant when we come to the question of whether he procured the breach. If he procures the undertaking because he can control what B Finance does, he controls how B Finance votes. And secondly, it is perfectly clear that Mr. Deripaska understood that the assurance that was being sought and the value of the undertakings that were being offered was protection in London because of the perceived, Mr. Deripaska may say misconceived, but the perceived risk my clients understood they would face of trying to enforce in Russia. So the offer is there being made in relation to a packet of shares in EN plus. And the other thing, so in a sense, 3 things we would ask you to get from this letter. 1 is procuring, 2 is not in Russia, and the 3rd is that what's being offered is an interconnected package of undertakings. They all and only make sense when they are interpreted by reference to each other, which is again one of the things the judge with the greatest respect disregarded wrongly. EN Plus, it was the entity, it's obviously a huge enterprise, and it's a matter of public record, as I say, that GDRs are quoted on the London Stock Exchange. It was originally, the company was originally incorporated in the BVI. It migrated to Jersey in 2005 and was listed in just as recently as 2017. And as I say, what was traded were the global depository receipts, not the certificated shares. That is explained in a number of witness statements. So there's no need to go to them. I don't think it's controversial, but just so that you've got an evidential note that it's the GDRs, not the shares, that are traded. That's it in McGregor 2, para 57, which is in the supplemental bundle. We don't need to go to it. Supplemental bundle, tab 30, page 140, and Makarov 17, which we also don't need to go to. Makarov 17, which is supplemental bundle, tab 37, page 223. There is then a letter from Clifford Chance in response, 30th of May, which is tab 7, page 40. And you'll see from paragraph 3, this is actually responding to a letter that isn't in the bundle. We can get the letter it's responding to if you would like. The only reason I mention that is that if you look at 3B, they're talking there about the suggestion of a Russian bank guarantee. The response is in 3b, you're aware of our client's position supported by extensive evidence that's put before the court in the course of obtaining worldwide freezing order that there are likely to be severe and potentially insuperable obstacles to enforcing it against Mr. Deripaska in Russia. Those concerns extend to the enforcement of Russian bank guarantee given on his behalf. They then say this, the location of the underlying asset is irrelevant. When one sees the letter that this is responding to, it is apparent that what the underlying asset in inverted commas is TGM, is the Russian company that owns the site in Russia. The location of the underlying asset is irrelevant. What BCLB had said is, well, look, you know, the assets, the joint venture assets in Russia, you shouldn't be complaining about being offered a Russian bank guarantee. And we're saying, well, the location of the subject matter of the joint venture doesn't matter. Our clients have obtained injunctive relief in respect of the award of an LCI arbitration tribunal in London. Together with associated costs and interests, they put before the court evidence that it will be difficult or impossible to enforce their entitlement in this regard in Russia. If your client wishes to avoid the effects of the freezer, he must provide proper security that does not inter alia depend on enforcement action in Russia. And then at 4C, there's to be an agreement for the provision of voluntary security for the purposes of 9E2 of the freezer. Our clients will require that appropriately valuable and liquid assets are identified in the UK or EU, which are owned in a manner that allows effective security to be given over them. By effective security, we mean that it is capable of being swiftly enforced by our clients by action in the English or other EU courts without relying on undertakings of third parties outside the jurisdiction of such courts. If a client has any serious proposals to make, invite you to put them forward. So again,
that's in the context of saying that EN shares don't fit the bill.
that is in the context of
4A.
yes, that is yes.
So for the EN plus shares don't fulfil don't fulfil the concern expressed in 4C because they are rejected.
Merely an undertaking it by B Finance in relation to the EN plus shares didn't. But when the package is then developed such that Mr. Deripaska personally gives an undertaking that he won't take any steps that frustrate the performance by B Finance of its undertaking.
Except the objection to EN plus shares are twofold. They're volatile in price and liable to be illiquid.
Those are objections, yes, I agree. But ultimately, those objections weren't as I say, weren't of sufficient concern ultimately for my client to reject the package that then emerges, which has the three elements of an undertaking by B Finance that it will sell a sufficient number of the shares, an undertaking by RPC that it will hang on to the share certificates and not deal with the share certificates or the shares, and an undertaking by Mr. Deripaska that he will not do anything that frustrates, impedes, I can't remember the trio of words, impedes, prohibits or whatever, the performance by B Finance of its undertaking. So it is the evolution of that package of the three undertakings that ultimately it is what persuades my clients to accept them. And what emerges very clearly from this is that the package is evolved in response to these stated concerns about the problems that would face my clients in seeking any enforcement in Russia. We then get the BCLP response over in the next tab, tab 8. And the relevant paragraph is on page 44. We therefore inform you that Mr. Deripaska is the ultimate beneficial owner of B Finance which is the legal owner of at least 150 million unencumbered shares in EN Plus, a Jersey company. Of these, Mr. Deripaska has offered undertakings in respect of a block of 35.5 million, which are currently held in certificated form in London. The total value of these shares at the present date is believed by our client to be no less than 160 million. In reality, he believes it's considerably more. Although he doesn't own those shares directly, Mr. Deripaska has offered by the undertakings to treat this block of certificated shares as frozen and amenable to enforcement should Mr. Chernukin and Navigator succeed in the ongoing arbitration claims, and should Navigator be in a position to transfer its shares in Navio to Mr. Deripaska. So the evolution of negotiations, responsive to the concerns expressed about the inability of my clients to enforce in Russia, is met with the offer of Mr. Deripaska giving an undertaking to treat the block as frozen in London. And so again, one sees perfectly clearly that the context in which the undertaking is offered, and we would say the context in which it should be interpreted, is the risk of any need to resort to proceedings in Russia. And then we get much the same from Mr. Ray's witness statement. He was the solicitor then representing Mr. Deripaska. And again, the themes one gets here are the same that we've already seen. Essentially, that the undertakings are being offered to replace the freezer, that it's a package of interconnected undertakings which operate together, and therefore we submit needs to be interpreted together. And the third theme that we get from this is the one we've already seen, that the offer is by Mr. Deripaska. He is procuring the offer of the undertaking, that is relevant to the judge's finding that he procured the vote in due course. And one sees that paragraph. So those three themes one sees in paragraphs 8, 11, and 12. I don't need to, I think, spend time reading those. And we move then to the next tab, a letter from BCLP, 6th of June. And again, we get the same themes of a recognition of that in order for the undertakings to be acceptable, my clients have to be offered something that is held outside Russia. And it is all clear that what is being procured by Mr. Deripaska, albeit through various corporate vehicles, which is relevant, as I say, to whether or not he procured the breach that we say ultimately is committed. And we see that from the passages on the first page, the first substantive paragraph. His offer by undertakings to the court from himself, B Finance and RPC to treat certificated block of so many shares. And then the numbered paragraph 1. In this regard, we would point out that 1, shares held in England, subject to these undertakings and confirmation of assets held by a BVI company whose director has given an undertaking to the English court, are of substantially greater value than an asset held by Mr. Deripaska's sole name in some other jurisdiction, which is not as readily realisable. And then over the page, numbered 4, it's clear that on the basis of what the judge said he had in mind, safekeeping in England and Wales of shares in EN Plus with suitable undertaking would have been sufficient to meet both the asset preservation and disclosure requirements of the order. And then tab 11, page 56, we get Clifford Chance's response. Numbered paragraph 4 quotes a letter which isn't in the bundle, but they're quoting back to Relevant Supporter Chamberlain, some assertions made about Mr. Deripaska's ability to procure the undertakings being offered, which, as we say, is further evidence in relation to the theme we've developed about the procuring of the breach in due course. If he procures the undertaking, it's he that's procuring the breach. And then page 59, para 12. I don't think we need to dwell on that. That's going back to the Russian bank. Very quickly then, the same themes recur as the correspondence develops. Tab 13, paragraph 2, we see that an undertaking is being offered, again, perfectly obviously, to replace the worldwide freezing order. And we then get in paragraph 4, the proposed undertaking from Mr. Deripaska now contains wording that he will not deal with his assets such that they will remain available for direct enforcement against him. We understand that to be the extent of your concerns as regard his undertaking personally. So we see the evolution of the package that's being offered in response to the concerns that have been expressed. Paragraph 8 over the page, there's proposed a mechanism for applying back to court if the value drops. And I just draw that to your attention because the value, well, Mr. Deripaska's net worth has never been the concern. He can afford 100 million. The concern was always access to an asset against which enforcement could be made. So if the value of the shares in the in-class dropped, well, we could apply for more shares to be scooped up within the mechanism. But it's the availability of assets which are amenable to enforcement that matters, not Mr. Deripaska's net worth. And paragraph 10, we just draw to your attention because it emphasises again the interconnectedness of the package of undertakings, in particular the significance of the Reynolds Porter Chamberlain undertaking to hang on to the share certificates. Your suggestion that the undertaking by Rupert Boswell, that's of RPC, without value, while it is correct that the shares are not bearer shares, the share certificates provide evidence of ownership without which trading in the shares is not possible. The undertaking of Mr. Boswell provide comfort that there is no risk of dissipation of the assets. So when one is interpreting the package of undertakings, it is important to recognise that the context in which they were being offered and the purpose of the RPC undertaking is to ensure that the shares, the subject of the undertakings, could not be dissipated because they couldn't be sold without the share certificates. We've cited in our skeleton argument various references to passages in the submissions of counsel, which are in the supplemental bundle at tab 16, page 76. I don't ask to go to those, and we've also added some at tab 50, page 363, which I think, in the interests of moving forward, I don't need to go to. So we then get to the key point of actually interpreting the undertakings, and I hope without undue emphasis it will be apparent that we submit that the relevant context is apparent from what we've been looking at, that the context in which the undertakings needs to be interpreted includes my client's concerns regarding, which really flow from the breakdown in the relations between Mr. Chernukin and Mr. Deripaska, that led to the armed takeover, the dishonesty shown by Mr. Deripaska on his part in putting forward a false claim as to who his joint venture partner was, which evidence in our submission clearly his willingness to thwart recovery. The fact that there was a very substantial arbitration award, the objectively justifiable concerns my clients had about the risk of Mr. Deripaska retreating assets to Russia and my clients' likely difficulties in enforcing in Russia. And the fact that Mr. Deripaska and his advisors were well aware that those were our clients' concerns and they sought to meet them by the undertakings that were being offered. And those undertakings, as I say, were plainly offered in return for our agreements to lift the freezing order, and most importantly, the undertakings represented a package of interlinked obligations which need to be construed together. And that was a point that the Court of Appeal made on the last occasion, referring to them as a package of linked undertakings in a suite of documents. We don't need to go through that. Paragraphs 10, 11 and 13 of the Court of Appeal judgment on the last occasion of tab 44 of the supplemental bundle. A package, a package of linked undertakings, a suite of documents. And so clearly what mattered to Mr. Chernukin was the availability of assets against which enforcement could readily be made in reliable jurisdictions such as England and Jersey, not in Russia. My learned friend has said in his skeleton, and we can respond if these points are developed in his oral submissions, but I just mention and respond preemptively now. My learned friend says in paragraphs 55 and 56 of his skeleton that the context is disputed. He says there's a dispute as to the context in which the undertakings were given. In our submission, that is a mischaracterization. Mr. Deripaska may well have felt that the freezing order should not have been granted. He may well have felt that there wasn't a risk of dissipation. He may well have felt that our evidence of his influence in Russia is overstated. But the context is not that my clients were right about all those things. The context about which there cannot be a dispute is that my client had those concerns. They were objectively justifiable, and they were known to Mr. Deripaska and his lawyers because they formed the context in which the undertaking package was specifically offered and enhanced in negotiations in order to meet precisely those concerns. So for my learned friends to say that there is a dispute about the context, in our submission misses the point of what the relevant context is. We're not saying there was a common view between the two parties about the risk of enforcement in Russia or the risk of dissipation. We're saying that my clients had those concerns. Mr. Deripaska and his lawyers knew we did, and they offered the undertakings in order to meet those concerns, and that is the indisputable context in which the undertakings fall to be interpreted, which is what we now need to do. So if we can turn to the B Finance undertaking, which is in the core bundle at tab 10. And you'll see it's prefaced by a letter from Fidelitas, which is the holding parent of B Finance. And they say, we Fidelitas, and then if we just bump down to the fourth line, consider that these undertakings in the company's best interest, having regard to the worldwide freezing injunction to which these undertakings relate, and the prospects of this injunction being extended if the undertakings are not given. So again, that's part of the context. Mr. Deripaska may well say the injunction should never have been given, but the context was it had been granted and they knew there was a risk that it would be continued. And then if we turn over to the undertaking itself, paragraph 1, again, the director, Mr. Vishnievsky, says he's writing in connection with the worldwide freezing order obtained by the claimants. He says in paragraph 2 that he's the sole director of B Finance. The ultimate beneficial owner of the company is Mr. Deripaska. In paragraph 3 is the critical point. It's the definition of what is the subject matter of the undertaking. I confirm and warrant that the company, that is B Finance, is the legal owner of over 245 million unencumbered shares in EN Plus Group PLC, a company incorporated under the laws of Jersey, EN+. Of these, 45.5 million are held in certificated form, capital S, the shares. The definition of the shares in this undertaking is certificated shares in a company incorporated under the laws of Jersey. That is the subject matter of the undertakings. So whenever we see the shares, that is what it's talking about. 45.5 million certificated shares in a Jersey registered company. And the substance of the undertaking, paragraph 5, undertake to the court as follows. A, the company will arrange for original share certificates in respect of the shares, share certificates, to be deposited at the offices of Reynolds Porter Chamberlain in London. That would be a pointless provision if the subject matter of the undertaking was any shares, certificated or not, in an EN+ entity, irrespective of where it was registered. One has to give real value and meaning to the concept of interpreting these undertakings on the basis that they are interlinked. They make sense together because they are mutually supportive. There is no point in including deposit of share certificates if the fact that they are certificated shares in that Jersey registered company isn't the point. It's the purpose of the undertaking. And 5B, the company will not dispose of the shares or otherwise deal with them, pending the final outcome of the proceedings. It won't dispose of or deal with 45.5 million certificated shares in a Jersey registered company. C, I and the company will irrevocably instruct RPC to hold the share certificates and not to deal with or dispose of or otherwise deal with the shares in any way. Again, it's an undertaking relating to the certificated shares in the Jersey registered entity. And then D is B finances obligation in a sense to satisfy the arbitral award if Mr. Deripaska doesn't within a fixed period of time. And you'll see from 2, 4, 5 lines down, the company will take all necessary steps to sell such quantity of the shares, capital S, as defined, as is required to meet any balance of such payment which may be outstanding, and for the proceeds of sale to be used to satisfy such outstanding balance, following which all undertakings contained in this letter shall immediately lapse. And then paragraph 6 is English law and submission to the English court, which again resonates with the recognition that my clients did not wish to be trying to enforce completion of any enforcement in Russia. And then over the page, without prejudice to 6 above, I understand and agree that the undertaking set out above may be relied on in any proceedings brought in the courts of the BVI to enforce their terms. So in our submission, that is perfectly clear in defining what is the subject matter of the undertakings. And as I say, one gets the significance of the fact that they are certificated shares in the Jersey registered company from the context, knowing that RBC is being given the share certificates, which would be a pointless exercise if the undertaking only related to a share in an EN+ entity, irrespective of where it was incorporated and irrespective of where the shares were certificated. We then get to the RPC undertaking, which is actually in tab 12, and it has essentially the complementary structure, as you might imagine. The first paragraph says he's writing in connection with the Worldwide Freezer. He writes further to his letter of today's date from Mr. Wisniewski, which we've just seen. And in the third paragraph, he says he confirms that the original share certificates, in respect of 45.5 million shares, the shares in EN Plus Group PLC, a company incorporated under the laws of Jersey, have been deposited at the offices of Reynolds Porter Chamberlain. The definition of the shares, again, is by reference to the fact that they are certificated shares in a Jersey registered company. The significance of that definition we've already emphasised, its relevance. It is perfectly clear in the context of an undertaking to hold those share certificates, an undertaking which would be pointless if Millennium Friend's interpretation were correct. For the fourth paragraph, I hereby undertake to the court, in connection with the above proceedings and pursuant to irrevocable instructions I've received from the company, which owns the share certificates and the shares, that RPC will hold the share certificates and not dispose of or otherwise deal with the shares in any way pending the final outcome of the proceedings. And then the fifth paragraph at the bottom of the page, in the event of any final judgment and non-payment being made, he says he undertakes pursuant to irrevocable instructions received from B Finance that RPC will take appropriate steps to facilitate the sale of such number of the shares as are required to satisfy any order of the court. That undertaking, which is an integral part of the whole package, only makes sense if RPC is holding certificates in relation to the shares to which those certificates relate, which is a Jersey registered company. We quote, just a break from the undertaking very briefly in this context, we just flick back to tab 3 of the core bundle, page 25. You may have noticed we had made this point and it had obviously resonated with Lord Justice Snowden when we were last in this court. At the bottom of page 25, in footnote 5, we say, as Lord Justice Snowden asked rhetorically during the court of your hearing, how could B Finance sell shares without delivering the share certificate to the purchaser or procuring the delivery of the share certificates to the purchaser? You execute a stock transfer form, you deliver it together with the share certificates. In the course of subsequent exchanges, as the Lordship correctly observed, the key was, whilst they remain certificated shares, you have equitable security over them by the deposit of share certificates in London. So in our submission, it was quite clear in arguendo there that that Lord Justice Snowden fully recognised the significance of the interrelatedness of the undertakings and the significance of the RPC undertaking. And we then get to the Deripaska undertaking, which is tab 11, knowing what we know about the other two undertakings to which it is ancillary. And again, we get the same structure, essentially. Paragraph 1, writing in connection with the worldwide freezing order, because Mr. Deripaska knows perfectly well there's a risk that that will continue if he doesn't come up with security that's acceptable in its place. And paragraph 2, he writes, obviously, further to the letter we've seen from Mr. Wisniewski, the B Finance undertaking. Paragraph 3, he confirms and warrants that he is the ultimate beneficial owner of B Finance. Paragraph 4, once the undertakings have been provided by Mr. Wisniewski on behalf of B Finance, I understand that Fidelitas is unable to take any step to frustrate compliance with and or enforcement of the undertakings. Nevertheless, and for the avoidance of doubt, I hereby further undertake to the court in connection with the above proceedings as follows. I shall not take any step or procure the taking of any steps, whether directly or indirectly, in my capacity as ultimate beneficial owner, or in any other capacity, which has the effect of preventing, impeding, or obstructing the fulfilment of the undertakings set out in the B Finance letter, as they may fall due for performance, I shall take all steps as are necessary to ensure that the underlying assets, being the 45.5 million unencumbered shares legally owned by B Finance in EN plus PLC, remain available for direct enforcement. And then over the page, just for completeness, he acknowledges he's had the undertakings explained to him and the consequences of breach in para 5, and paragraph 6, we get the English law and the jurisdiction clause. So in our submission, it is apparent from the way that these 3 undertakings are structured that they are clearly intended to be mutually operable, in the sense that how they work and what they mean must be compatible. So, in terms of interpretation, when 4b says, I shall take all steps as are necessary to ensure that the underlying assets remain available for direct enforcement, what are the underlying assets? My learned friend seeks to gain some comfort from the fact that the words "a company registered in Jersey" don't appear here. And our submission, that is the merest drafting accident. The subject matter of the B Finance undertaking, which Mr. Deripaska is agreeing not to take any steps to impede, prevent, or obstruct, and to take steps as are necessary to ensure, the subject matter of the B Finance undertaking is perfectly clear from the face of the words used, the definition of the shares by reference to a Jersey registered company having the certificated shares. So as a matter of language and as a matter of the context with the interaction between the B Finance undertaking and the RBC undertaking, it is perfectly clear that the subject matter of the undertaking was 45.5 million certificated shares in a Jersey registered company. So when 4b of the Deripaska undertaking talks about the underlying assets, what he's talking about is the assets underlying the B Finance undertaking. It's got to refer to the same subject matter. You can't have interrelated undertakings which have a different subject matter. So the fact that the words "a company incorporated in Jersey" happen not to appear here doesn't make the slightest difference to the meaning. The underlying assets has to be the same assets as the B Finance undertaking, and the B Finance undertaking has got to be dealing with shares in a certificated shares in a Jersey registered company, because that's what it says, and that's what makes sense in connection with the RBC undertaking. Yes, I'm reminded that paragraph 2 of the Deripaska undertaking recites, I passed over when reading it, but the last sentence of paragraph 2 says, yeah. So just as a matter of clarity, certainty, there's absolutely no doubt. This is a package, it's got to be interpreted consistently to make sense of the substance of what is being offered, knowing the context, which is my client's overriding concern not to have to try pursuing any kind of enforcement in Russia.
And direct enforcement means compelling B Finance to sell the shares.
Well, I was just going to get to that in a moment. I'm just dealing with underlying assets first. We submit that is absolutely clear what underlying assets means. Just harking back to the exchange we had right at the beginning, my lord, if you are with us on what the underlying assets were, we will submit that there has plainly been a breach, because what has happened has unarguably resulted in the underlying assets no longer existing. The subject matter of the undertakings has gone. If you accept that, I'll come to breach in a moment, but just to anticipate, if you accept that, we don't in fact also have to satisfy as to what direct enforcement means, because the undertaking relates to the underlying assets, and if the steps that have been taken result in those underlying assets no longer existing, then there will have been a breach. So I just wanted to put that thought with you before going to what direct enforcement means. Because, as I say, if you're with us on what the subject matter is, on what underlying assets means, then we don't need, in a sense, to worry about what direct enforcement means. It's only if you are not with us on underlying assets that it would matter whether we can satisfy you that what has happened has resulted in some shares in an EN Plus entity not being available for direct enforcement. So it would only be in that context we need to establish what direct enforcement means. We submit that seen in the context of the package of undertakings as a whole, the repeated reference to the worldwide freezing order, which has the express carve-out of assets in Russia, and in the context of all the preliminary correspondence we've seen and the negotiation of the undertakings, what direct enforcement means in that context is that the undertaking is being given to keep assets available for direct enforcement in the sense of being amenable to enforcement through the mechanisms contemplated in the undertakings. That is, enforcement in jurisdictions, England, Jersey, BVI, not Russia. Not Russia is the point. My learned friend submits that direct enforcement simply means that B Finance would hold assets, and that B Finance will be amenable to being pursued. We submit that that does not give proper value to the words read in the context that we've seen, remain available for direct enforcement. Available in context means not having to have resort to the one jurisdiction where my clients have their known justifiable concerns about enforcement.
Not sure that I entirely understand that. The means of enforcement would be by getting the court in England to compel B Finance to sell the shares wherever they happen to be in the world.
Yeah.
And that, on the face of it, seems to be enforcing the B Finance undertaking in England.
Yeah.
And if B Finance did not then comply with a court order, it would be liable to contempt, either in England, and its assets in the BVI could no doubt be sequestered. So why your client in that scenario doesn't need to go anywhere near Russia?
Well,
does he?
An English court can order shares to be sold. Maybe appoint receivers over the shares in order to sell them. The mechanism doesn't matter. While the company is a Jersey registered company, any sale would need to be registered in the register of members in order to perfect the transfer. While the company is registered in Jersey, that works, so to speak, because Jersey is a jurisdiction that my client would have confidence in an English court judgment being enforced. The difference is that once the company has been migrated to Russia and the register of members is held in Russia under Russian law, whatever an English court may say ultimately, perfection of a sale could not be achieved without resort to some step in Russia, which is exactly what this whole package was intended to avoid. Because no person is going to buy a share in a company unless they have confidence that they are going to get registered. They did have that confidence when the company was Jersey registered and RPC had the share certificates. That confidence evaporates, and in passing, Mr. Justice Tier recognised this in July 2019. That confidence evaporates when the register moves from Jersey to Russia, because although B Finance remains subject to the irrevocable undertaking to submit to the jurisdiction of the English court, the perfection of any sale will still depend on entry on the register in Russia, which it didn't so long as the company was registered in Jersey. And that was the point we've made. I was going to take the court just to a few points. In fact, I might just do that now. So there are just a couple of documents we can look at very briefly to show that that has always been the way the case is put. So Ms. Berard giving evidence, she was cross-examined before Mr. Justice Andrew Baker. If you can just look very briefly at Supplemental Bundle tab 42. Page 250. Where Ms. Berard is being asked about the value. And it's put to her that the value, lines 9 and 10, it was being put to her that the value was not adversely affected by the continuance. And her answer, and this in a sense is a neat encapsulation of our case, my client's case, well, the value only resides in terms of the enforcement possibilities for our client. The fact that the shares were now shares in the Russian company presented numerous difficulties in terms of enforcement. So I don't accept that the redomiciliation doesn't affect the value of the shares by BFNS insofar as they were security for my client. One sees similar from the interventions of Lord Justice Snowden in the Court of Appeal, who understood that point. So in the next divider, page 254, and you get there, in fact, page 254, so it starts at the top left, line 13, which is the bit that we quoted in the footnote that I just took you to, and Mr. Pillow, then representing Mr. Deripaska, says when it's put to him that you execute a it should be a stock transfer form, you deliver it together with a share certificate, you do in the Jersey company. The question is, when it became a Russian company, was that process impeded or obstructed? In my submissions, there's no evidence to suggest that it was. if B Finance refused to comply, the court would order it to execute the document required to transfer shares in Russia to a buyer. And Lord Justice Stone says the court that had jurisdiction over B Finance, because only the English court or the VI court would be able to order B Finance to comply with its undertaking to sell the shares, which it is accepted would apply to the Russian shares. How does that get given effect to, bearing in mind that the company is in Russia? And the transfer of shares, uncertificated, can only, therefore, be given effect in Russia. So the Court of Appeal on the last occasion was fully alive to that being our case. And it was the oral submission that I made, if we just go on to actually the next page, 255. When I was on my feet, so the bottom left-hand page 358 of the transcript, where I recorded saying the reason why structure was important was precisely to make sure that there was an effective mechanism for enforcement against assets in London.
Sorry, where are you, Mr.
Oh, I'm so sorry. So page 255 of the bundle,
Yeah.
page 358 of the transcript, so the bottom left-hand page. The reason why structure was important was precisely to make sure that there was an effective mechanism for enforcement against assets in London. And you say, do you, that the judge misunderstood? It's not about value, it was all about enforceability, and that is maintained. Technically, Lord Justice Snowden chips in, technically the assets are in Jersey, the certificates are in London. Fair point, my lord, absolutely right. The key was, my answer is not Russia. And that, in our submission, makes clear that that is the way the case has been put as long ago as 2021. And it was the submission that I made to the judge below at tab 48 in this bundle. If we look at page 346 of the bundle,
Tab 48.
Tab 48, page 346 of the bundle, line 14. This is me speaking. The value to my clients of the share certificate is not that they are themselves a tradable commodity, but that they prevent a sale of the B Finance shares, and the share register being in Jersey rather than in Russia provides the protection my client is entitled to. My learned friend said, and this I think is a legal proposition, that the shares remained exactly the same before as after the redomiciliation. And as with all legal propositions, the question is, from whose perspective are you viewing that? If you're viewing it from the perspective of the shareholders, the answer may well be, well, they still hold the same pro rata interest in the same economic undertaking, yes. But as a matter of law, from my client's perspective, they are totally different, because B Finance is then free to sell the shares because it does not need the share certificates to do so. And it doesn't, and if it doesn't sell the shares and pay the proceeds to my client, and my client tries effecting a sale of the shares, it has to go chasing a share register in Russia. Who is ever going to buy shares from anybody appointed in this jurisdiction as a receiver or whoever, where the share register are in Russia? That, in our submission, is probably the nub of the whole case. And that is, as it happens, what appears to be one of the principal reasons why the Court of Appeal overturned Mr. Justice Andrew Baker's ruling. And it's a nice question whether they were making a provisional finding or an absolute finding in this regard. Can we just go back to the Court of Appeal judgment? So tab 44, page 282. Well, actually 281, sorry, start at 281. Paragraph 90. For the reasons explored in more detail below, I have reached the conclusion that the judge erred in the following central respects. 1, he reached his conclusions on the basis of 2 fundamental misapprehensions. And it's the second one with which we are currently concerned, B over the page. The fundamental misconception was that the redomiciliation was not damaging to the appellant's interests. Indeed, the judge appears to consider that it was possibly beneficial to them because it preserved and enhanced the commercial value of the shares in EN Plus Jersey / EN Plus Russia. The judge failed to appreciate that the appellant's concerns, which the undertakings were designed to address, were not so much as to the commercial value of Mr. Deripaska's interest in EN Plus Jersey or his wealth more generally, but rather as to the appellant's ability to enforce the award directly and readily against his assets outside Russia. If the effect of the redomiciliation was to extinguish certificated shares in a company incorporated in Jersey and to replace them with dematerialized shares in a company incorporated in a ring-fenced zone in Russia, this could readily be seen to be adverse to the appellant's ability to enforce the award against those assets. And picking it up again at 99, in fact, I've already read the relevant bit of 99, the essential purpose and effect of the undertakings has been missed by the judge. The undertakings were all about securing assets for the appellants that were outside Russia and available for ready enforcement of the award. And in our submission, that's absolutely right. That is what we wished to say on, by way of opening, on interpretation. We say the undertakings are interlinked, they are mutually supportive. What they mean, what each one means, can only be properly understood by reference to what the others do. And on that basis, and in the context we have seen, in our submission it is perfectly clear that the subject matter of the undertakings, the underlying assets referred to in Mr. Deripaska's undertaking, is 45.5 million certificated shares in a Jersey registered company. Breach. We accept that any contempt must be proved to the criminal standard. No difficulty about that. In order to see whether a breach occurred, we just need to pick up the chronology very briefly, and I'll try and do this as rapidly as I can. The redomiciliation, or the migration from Russia to, from Jersey to Russia, was prompted essentially by the imposition of sanctions, not only against Mr. Deripaska personally, but against EN Plus itself. As it happens, sorry, just to give you, we don't need to go to them, but the fact that the US sanctions were the driver for the redomiciliation is apparent throughout the evidence from Mr. Deripaska, but most clearly perhaps in Mr. McGregor's first affidavit, McGregor 1, para 75, which is supplemental bundle, I don't ask to go to it, but supplemental bundle 36, supplemental bundle tab 36, page 211, and Mr. Makarov's statement, paragraph 13.1, which again we don't need to look at, but just so you have the note, it's in the supplemental bundle tab 37, page 221. As it happens, before the US sanctions, EN Plus had been considering a redom to another jurisdiction, but it decided to go with Russia following the sanctions. And the chronology, very briefly, so you've just got it in mind. 1st of November 2018, the board of EN Plus make the initial decision to pursue redomiciliation. The notice of the shareholder meeting to approve the redomiciliation went out on the 30th of November. And on the 20th of December 2018, that EGM was held, and EN Plus shareholders passed the resolution approving the redomiciliation to Russia. And the factual basis of the allegation of contempt is that Mr. Deripaska procured or permitted B Finance to vote in favour of that resolution. Just while we picked up the threads of the chronology again, just to keep things all in context, so that was November, December, the notice and the holding of the EGM. Also in November and December 2018, coincidentally, was the commercial court trial before Mr. Justice Tier, and he gave his judgment in February, early February the following year. We don't need to go to it, but it's in the authorities bundle at tab 9, page 170. And if you read only 3 paragraphs, we would invite you to look at paragraphs 283 to 285, where he finds that Mr. Deripaska gave knowingly dishonest evidence. His whole case was dishonest because he was pretending he wasn't the joint venture partner and he had paid Miss Danilina to give false evidence, which she knew was false. I emphasise that because it will come back to relevance when we come to the argument about costs. So paragraphs 283 to 285 is the dishonest case. So that's the judgment in February 2019.
So you said Mr. Deripaska was pretending that
Ms. Danilina was the joint venture partner.
and not Mr. Chernukin.
Exactly.
I think you said it the wrong way round.
Oh, I'm so
Anyway.
sorry. Did I? I'm so sorry. I apologise.
Miss Danilina
Ms. Danilina's name
was the
on the
real joint venture partner with him.
that Mr. Deripaska's case, both at the jurisdictional stage in the arbitration and at trial when he was challenging the jurisdiction of the tribunal, Mr. Deripaska's case was that his true joint venture partner was Miss Danilina, not Mr. Chernukin. And he had paid her to say that, and she earned her 2 million.
Because for
And
one
was
reason,
disbelieved.
Chancellor used Miss Danilina when they were in a relationship to front on his behalf, and then they fell out with each other. And effectively, what the judge found is that Mr. Deripaska took advantage of that to tell a complete pack of lies about who the joint venture partner was.
Exactly. And both the arbitral tribunal and Mr. Justice Tier, having heard cross-examination, came to very clear findings on that. So that's the judgment of Mr. Justice Tier, the trial judgment for early February 2019. April 2019, Mr. Deripaska launches a private prosecution against Mr. Chernukin, alleging that he had done acts tending and intended to pervert the course of public justice in presenting false evidence in the trial, based on a document which Mr. Justice Tier found was backdated, but was backdated to vindicate a case which Mr. Justice Tier accepted was in fact a true case as to Mr. Chernukin's position. So Mr. Deripaska brought a private prosecution, which the CPS then took over and discontinued. I mention that simply because when it comes to questions of an evaluation of how Mr. Deripaska's case is described, which was taken into account in awarding indemnity costs, the level of animosity shown and the willingness to cause my client at best inconvenience, but most importantly to thwart enforcement, was an extremely prominent part of the relationship between them after the breakdown in 2010. So just rapidly moving through the rest of the chronology, April 2019, 18th of April 2019, moving back to the re-domiciliation, the shareholders have passed the resolution in December 2018. The new independent board of EN Plus approves the re-domiciliation in April 2019, and the Jersey Financial Services Commission gives approval on the 16th of May 2019. That chronology is in our submission important because it is only...
Do we know anything about the principles, if any, upon which the Jersey Financial Services Commission either give or refuse to give permission to re-domiciliation? Because under the Jersey law, it simply says they may grant approval.
Yeah.
Which on the face of it implies a discretion to say either yay or nay.
Yes. I don't believe there has been any evidence about the tests that they apply. The legislation was in evidence, and there is one letter from the JFSC that says they at one stage were provisionally minded not to agree because, as we will see in a minute, my client had got injunctive relief in Jersey requiring the Jersey shares to be registered in the name of the Viscount, who is a sort of official receiver in Jersey.
Yeah.
And the JFSC was concerned that approving the migration to Russia might frustrate the effect of a court order. That is simply an illustration of a factor that appears to have been provisionally taken into account but ultimately
I asked
overridden.
the question because the application notice alleges that the vote was determinative of the redomiciliation, which seems to invite the court to say that the Jersey Financial Services Commission is simply a rubber stamp. And I'm not.
Can I come to determinative in a moment? But yes, because I absolutely will address that. But it hopefully will make more sense of my submission if I can just do it in a few moments. So just in terms of chronology, what I wanted to emphasise is that the JFSC gives its approval on the 16th of May, and then just a few days later, on the 29th of May, Mr. Deripaska instructs Reynolds Porter Chamberlain to write to my client, drawing his attention to the redom in terms that recognise that the redomiciliation will mean, so they say, that the undertakings have to be withdrawn. Both the timing and the content of this letter are important because the timing of it we put to Mr. Deripaska in cross-examination as suggestive that he knew perfectly well the redomiciliation involved a violation of the undertakings, and he didn't want to flag that point to Mr. Deripaska until after the JFSC had given their approval. And the content of the letter is similarly critical, not just the timing, the content. If we can go to it, it's in tab, the supplemental bundle, tab 24. And you'll see that it refers to the release of EN Plus from the US sanctions. I mean, the backstory, I don't know if you follow this, but there was the Lord Barker was the chairman of EN Plus, and he conceived of a plan to try and get EN Plus released from its sanctions with essentially two elements, being the reduction below a controlling interest of Mr. Deripaska's shareholding in EN Plus, and the appointment of a new and independent board so that Mr. Deripaska didn't have executive control over the company either. So the Barker plan, which worked, was to persuade OFAC to release the sanction against EN Plus by Mr. Deripaska shedding both shareholder control and executive control at board level. And so that's what's being described in brief terms in the first few pages, the first few paragraphs. And then we get on page 121 of the bundle to the continuance, and it describes the steps that have already been taken before this letter goes out. And then paragraph 7 is the critical one. We are instructed, and I obviously put to Mr. Deripaska in cross-examination that was him giving the instructions to his solicitors. We are instructed that once the continuance of EN Plus takes place, its shares will be held in dematerialised form, i.e. share certificates will not be issued to shareholders. The existing shares and share certificates in respect to Jersey domiciled EN Plus will be automatically cancelled, including the share certificates held by RPC pursuant to the undertakings previously given by Mr. Deripaska, B Finance, and Rupert Boswell, in respect of 45.5 million certificated shares in EN Plus owned by B Finance, the undertakings. All shareholders in Jersey domiciled EN Plus will, at the point the continuance is completed, automatically be granted new shares in Russia domiciled EN Plus on a one-to-one basis. EN Plus's listed global depository receipts will continue to be traded on the London Stock Exchange as before. The current undertakings refer to certificated shares in EN Plus and are based upon the Jersey share certificates in EN Plus being held by RBC. In light of the continuance, the undertakings will, with the permission of the court, need to be withdrawn. Now, that may or may not be evidence that's admissible as to interpretation of the undertakings because it's so far after the event. But it is perfectly clear evidence of what Mr. Deripaska understood the effect of the redomiciliation was. And the letter ends, paragraph 15. We look forward to hearing your client's position on the contents of this letter. In the event that they consent in principle to the withdrawal of the undertakings, we will circulate a draft consent order to that effect. If they will not, our clients will have no choice but to issue application to the court for the release of the current undertakings and appropriate directions. So it was expressly Mr. Deripaska's own case that the result of the redomiciliation was that the undertakings had to be withdrawn because they ceased to operate. The subject matter of the undertakings didn't exist anymore. That was no sort of slip of the hand written in haste. Was the position maintained, if we see the following month, tab 25, page
It wasn't merely that the subject matter of the undertakings didn't exist in the way in which you've been using that phrase. It was actually that the shares didn't exist anymore.
Well, absolutely.
And new shares would have to be issued.
Absolutely, absolutely. That was avowedly their position. And you'll see that those words are quoted in the committal application.
Yes.
Page 123 is RBC the next month. We note that you'll be writing to us later this week. You contend that any application made by our client in the meantime would be misconceived. That's not accepted, particularly in circumstances where the certificated shares on which the undertakings are based will shortly no longer exist after the continuation has completed. And then correspondence carries on. Efforts were made, we'll just see, I don't want to spend too long on this. Efforts were made, if you just look at the next letter, which is from Clifford Chance. Clifford Chance was saying, well, look, can we get some shares in EN Plus that are covered by the GDR quotation, covered by an undertaking, because that would be an asset outside Russia. When you see that paragraph 8 of this letter, on the last page 126 of the bundle, it's plain and sensible that shares available for direct enforcement under the terms of the current undertakings given by Mr. Deripaska should now be entered into the GDR programme and appropriate undertakings given in order to ensure that the resulting GDRs are kept available for enforcement outside Russia. We invite your client's agreement, and then as a procedure that simply didn't work. And we get the letter from RPC at tab 28, page 134. Just look very briefly at page 135. You'll see paragraph 11A, at the very bottom of the page, 11A. We can confirm that the following response to the in response to the specific queries of paragraph 4 of your letter. The Russian Central Bank registered the issuance of shares in EN Plus as an international public joint stock company on the 24th of June. We are instructed that whilst it's not possible to give a definitive date, the anticipated date on which EN Plus will be registered in Russia as a Russian legal entity remains as set out in our letter of 29th May, on or around 4th July. And the continuance will be completed shortly thereafter. We are instructed, however, that the date of registration is outside the control of EN Plus. it is upon the registration of the Russian legal entity that any shareholder would, if minded to sell all or part of its EN plus shareholding, be required to sell its shares and or GDRs relating to those shares in the new Russian entity, and would no longer be able to sell its shares and or GDRs relating to those shares in the Jersey entity. And they conclude at paragraph, absent a change in position by your clients, it appears that our client will be left with no choice but to issue an application to seek the court's permission to withdraw the undertakings in light of the continuance. And they say, we've got to get on with things. And indeed, I think on that very day, yes, it was, 26th of June, on that day, Mr. Deripaska did issue an application to lift or withdraw the undertakings. That application isn't in the bundle, but it's referred to in paragraph 22 of the Court of Appeal judgment. My clients issued a cross application for payment into court of the full amount of the award. That was supported by Mr. Barrard's fourth witness statement, which you get an extract from the next tab 29. And you'll see from paragraphs 61 to 64, she makes the same point that we've made throughout about the difficulties of enforcement in Russia and the importance of having protection in relation to assets outside Russia. I mentioned the Jersey proceedings. They're not critical, but just to give you the chronology of those, in late June, 28th of June 2019, a representation as far as legal proceedings were commenced in the Royal Court in Jersey, seeking the appointment of a receiver and other relief. And the Jersey Court ordered the 45.5 million shares in the Jersey EN Plus company to be registered in the name of the Viscount. The Viscount was duly registered as the legal owner. After migration to Russia was completed in July, my clients went back to the Jersey Court, and on the 12th of July, the Jersey Court granted an injunction preventing Mr. Deripaska from dealing with or disposing of the replacement shares in EN Plus Russia, and requiring the Viscounts to hold any such shares to the order of the Royal Court.
Any such shares being the dematerialised shares in the Russian entity.
But despite best efforts on my client's part, we never did find out whether, in fact, the Viscount was ever registered as the holder of any shares in EN Plus Russia. And that merely provides a sort of footnote illustration.
It was all overtaken by subsequent events.
Yeah, no, absolutely. Yeah.
The money was paid and the undertakings were released.
Yeah, that's absolutely right. And that happened through a process that was held, well, to shorten it. Mr. McGregor put in evidence which explained in a witness statement the position that had been taken in the correspondence.
Well, in his witness statement, he simply repeats in a little bit more detail, but not much, what he said in the letter, which presumably was his letter. So it's page 139 of the bundle.
Exactly so. So I was just going to give you the page reference. You're obviously onto that. That then led to the hearing in front of Mr. Justice Tier on the 3rd of July, who ordered the full amount of the award to be paid into court, and also mentioned, for what worth, that it seemed likely that the redomiciliation involved a breach of the undertakings. That's paragraphs 27 to 28 of his judgment, which is at tab 11 of this bundle. I don't need to go through that, but it is perhaps striking.
Well, he starts 28 by saying, in circumstances where the shares in the Jersey company are to be extinguished. It's difficult to understand.
And over the page at paragraph 30, it says this is a case where both parties say that the undertakings cannot now be effective or of any value. And he's having to decide on the basis that that was common ground what to do. And he ordered a payment into court. And one of the rulings of the judge below in this case on appeal to you, one of the rulings that the judge below made was that the payment of the full amount of the award that your lordship mentioned was only made by Mr. Deripaska because of the orders that Mr. Justice Tier made requiring a payment into court.
Yeah.
That's paragraph 26 of the judgment below.
Mm-hmm.
So where we get to then is that that's the sort of factual run-up to the breaches. And as you will be aware, we allege 3 breaches, and it may be convenient to have the committal application open in front of us for this, which is in the core bundle at tab 9. And there are common elements to each of the 3 breaches are pleaded on page 95. Paragraph 22D are the 3 breaches. They have common elements which are in paragraphs 22A, B and C. So I just wanted to go through those common elements very briefly. So at the bottom, page 94, paragraph 22, by reason of the matter set out above, Mr. Deripaska has breached the undertakings and is in contempt of court as follows. A, at a meeting of EN Plus shareholders held on the 20th of December, Mr. Deripaska, being the ultimate beneficial owner of B Finance, procured and or permitted B Finance to vote in favour of a special resolution to approve the continuance. That is the act by Mr. Deripaska which is alleged to constitute the breach.
Permitting B Finance to vote.
Yeah, procuring or permitting B Finance to vote.
The judge declined to make a finding of procuring, didn't he?
Yes, he did. So if we just look very briefly in tab 6 at page 54.
He said it didn't matter.
He said it didn't matter.
Mr. Deripaska could have stopped B Finance from
So
voting as it
he's saying he either procured or he permitted. It is, your lordship's obviously on top of this, paragraph 74 rather suggests that he was in fact finding that there had been a procuring. If you look at paragraph 74 at the last page of the judgment, I reject the alternative submission that by procuring the vote, the defendant either impeded or obstructed the fulfilment of by B Finance of its undertaking not to dispose of or deal with its shares for exactly the same reason. It would appear from that he is saying there was a procuring, although your lordship is quite right in paragraph 70.
I think that may be
He's describing the allegation rather than his
unclear,
finding.
frankly, because he's essentially rejecting the way in which you put your case.
But at the very least, we submit that there is a finding. The judge said it didn't make any difference, but that we had alleged procuring or permitting, and he found there was one or the other. In our submission, I wasn't going to spend any time on this in opening. Malone Friend seeks to, I think, to reopen that finding. If he does, I'll respond to it in closing. But we do submit that there plainly was evidential material, and I've already drawn your attention to quite a lot of it, namely the bare bones of it being that Mr. Deripaska was the ultimate beneficial owner of B Finance, and repeatedly in correspondence it was said that he could procure the undertakings, and the evidence was even if he didn't give direct instructions as to the voting of B Finance, he admitted in his witness statement, affidavit, that the vote was in accordance with his guidance, I think was the phrase he used. So anyway, there we go. The next issue was going to be to grapple with determinative, which your lordship's already raised. Would that be a convenient moment
Yes, that would be a
break?
convenient moment. 2 o'clock, please. Thank you.
Court rise if able.